941 of the mental hygiene law has to do with emergency admissions for immediate observation, care, and treatment, and what the powers of certain peace officers and police officers are. So this might be something that could be on it. I mean, maybe. I mean, I don't know. What are the powers of police or police officers as far as this goes? I don't know. So here we go. Any peace officer, when acting pursuant to his or her special duties, or police officer who is a member of the state police or of an authorized police department or force or of a sheriff's department, so that's state police, the police here, and the sheriff's department, may take into custody any person who appears to be mentally ill and is conducting himself or herself in a manner which is likely to result in serious harm to the person or others. The officer may direct the removal of such person or remove him or her to any hospital specified in subdivision A of section 939 or any comprehensive psychiatric emergency program specified in subdivision A of section 940. Now remember, in 939 the time for them to be able to stay is 15 days and 940 is 72 hours. Okay. Or pending his or her examination or admission to any such hospital or program, temporarily detain any such person in another safe and comfortable place, in which event such officer shall immediately notify the Director of Community Services, or if there be none, the health officer of the city or county of such action. This has a 15-day rule. And it talks about if the likelihood that they're to stay in a hospital, it's appropriate. If they're likely to harm themselves or others, and the likelihood to result in harm, as used in this article, is substantial risk to himself, as manifested of threats of or attempts at suicide or serious bodily harm, or the conduct demonstrating that he's a danger to himself, or substantial risk of harm to others by homicidal or other violent behavior, which people are placed in reasonable fear of serious physical harm. So the important thing to know here is that they may receive the hospital may receive and retain a patient for a period of 15 days if the person is alleged to have a mental illness for which immediate observation, care, and treatment in a hospital is appropriate. Okay. So if they're suicidal, they're allowed to go to, the emergency care, and it would be 15 days that they're able to take them. Okay. The director has to admit the person if they find that if they qualify under the requirements of the section, and they shall not be retained for a period of more than 48 hours unless within such period the finding is confirmed after examination by another physician who shall be a member of the psychiatric staff of the hospital. The person shall be served the written notice, all that stuff with the notice. If at any time after admission the patient, the relative, a friend, or mental hygiene legal services give notice to director in writing, request for a court hearing on the question of need for them to stay there, a hearing shall be held as herein provided as soon as practicable, but in any event not more than 5 days after such request is received. There is nothing. Okay. It shall be the duty of the director to forward forthwith a copy of the notice with a record of the patient to the Supreme Court or county court in the county where the hospital is located. So these hearings are done in where the hospital is located, in the Supreme or county court. So that's where the venue is going to be for these types of hearings. Let's see if there is anything. Oh, and then of course at the end of this section, as all the other sections, it says if a person is examined and determined to be mentally ill, the fact that they also or suffering from alcohol or substance abuse does not preclude the commitment under this section. So, and then, also within 15 days of arrival at the hospital, if a determination is made that the person is not in need of involuntary care and treatment, he shall be discharged unless he agrees to stay. So if he's in need of involuntary care and treatment and does not agree to remain as a voluntary or informal patient, he may be retained beyond such 15-day period only by admission to the hospital or another appropriate hospital pursuant to the provision governing involuntary admission on application support by medical certification and subject to the provisions for the hearing, review, and judicial approval or retention of the transfer. Okay. And now 940 has to do with emergency observation into a psychiatric emergency program. Now, I don't know if anybody knows, Stony Brook Hospital has a psychiatric emergency program. It's called CPEP. So this would apply for there. And I know, like, they've talked about this because people have said, oh, I can only get them in for 72 hours, for 3 days, whatever. So that's what this is. Okay, the director of any comprehensive psychiatric emergency program, which we can call Stony Brook's like CPEP. Yeah. They also have things there for like for juveniles, like emotionally disturbed kids and stuff like that. So it's just psychiatric, period. But they also have for adults and juveniles, which we're going to see in a little bit. Okay, so the director of any comprehensive psychiatric emergency program may receive and retain a period for not to exceed 72 hours. So again, the other emergency one is 15 days. This one is 72 hours. Any person alleged to have a mental illness for which immediate observation, care, and treatment in a program is appropriate and which is likely to result in serious harm to the person or others. The director shall cause to be entered upon the program records of who brought them there. This is different than the other one because I don't remember seeing this in the other one. I hope I'm not wrong about this, but it says that they'll cause to enter upon the program records the name of the person or persons, if any, who have brought the person there. And I don't remember seeing this in the other one, so I hope I'm right. Okay. This is definitely different, that they have to be seen within 6 hours. But I did a whole video I did this entire section, so I'm not going to really go into it. But just note that there is a difference between an emergency observation, care, and treatment in an emergency room. The other one just says emergency hospital, and this one says comprehensive psychiatric emergency program. So some hospitals do not have a comprehensive psychiatric emergency program, but they might have a psychiatric department, and it's different. Okay, so now we're on 943 of the mental hygiene law, and this is emergency admissions for immediate observation, care, and treatment. And this is a power of the courts. If they would ask anything, I would think that it would be something that happens in the courts or something that a clerk does, but you just never know. So here you go. Whenever any court of inferior or general jurisdiction is informed by verified statement that a person is apparently mentally ill and is conducting himself or herself in a manner which in a person who is not mentally ill would be deemed disorderly conduct, or which is likely to result in serious harm to himself or herself, such court shall issue a warrant directing that such person be brought before it. If, when said person is brought before the court, it appears to the court on the basis of evidence presented to it that such person has or may have mental illness which is likely to result in serious harm to himself or herself or others, the court shall issue a civil order directing his or her removal to any hospital specified in subdivision A of section 939 or any comprehensive psychiatric emergency program specified in 940, willing to receive such person for a determination by the director of such hospital or program whether such person should be retained. Whenever a person before a court in a criminal action appears to have a mental illness which is likely to result in serious harm to himself or herself or others, and the court determines either that the crime has not been committed or that there is not sufficient cause to believe that such person is guilty, the court may issue a civil order as above provided, and in such case, the civil action shall terminate. It does not say it shall dismiss. It says it shall terminate. 945, emergency admissions for immediate observation, care, and treatment. This is the power of the director of the community services. The director of community services or the director's designee shall have the power to direct the removal of any person within his or her jurisdiction to a hospital approved by the commissioner, pursuant to 939 or 940. Okay. If the parent, adult, sibling, spouse, or child of the person, the committee or legal guardian of the person, a licensed psychologist, registered professional nurse, or certified social worker currently responsible for the providing treatment service to the person, a supportive or intensive case manager currently assigned to the person by a case manager program, which program is approved by the Office of Mental Health for the purpose of reporting under the section, a licensed physician, health officer, peace officer, or police officer. If any of those people report to him or her that the person has a mental illness for which immediate care and treatment in a hospital is appropriate and which is likely to result in serious harm to himself or herself or others, it shall be the duty of peace officers, when pursuant to their duty, police officers who are members of the state police or the regular police department or the sheriff's department, to take into custody and transport any such person. Upon the request of a director of community services or the director's designee, an ambulance service as defined in, some section defined in subdivision 2 of section 3001 of the public health law, is authorized to transport any such person. Any person may then be retained in a hospital, pursuant to 939 or 940. Moving on, we have 946, reports of substantial risk or threat of harm by mental health professionals. Okay, so the term mental health professional in this section shall include a physician, psychologist, registered nurse, or licensed clinical social worker. Notwithstanding any other law to the contrary, when a mental health professional currently providing treatment service to a person determines, in the exercise of reasonable professional judgment, that such person is likely to engage in conduct that would result in serious harm to self or others, like this statute is all over the place, he or she shall be required to report as soon as practicable to the director of community services or the director's designee, who shall report to the Division of Criminal Justice Services, so that's DCJS, whenever he or she agrees that the person is likely to engage in such conduct. Information transmitted to DCJS shall be limited to names and other non-clinical identifying information, which may only be used for determining whether a license issued pursuant to Section 400 of the Penal Law should be suspended or revoked, or for determining whether a person is ineligible for a license pursuant to 400 of the Penal Law, or is no longer permitted under state or federal law to possess a firearm. Oh, so this is like the shootings or something, like the people. Oh. Nothing in this section shall be construed to require a mental health professional to take any action which, in the exercise of reasonable professional judgment, would endanger such mental health professional or increase the danger to a potential victim or victims. The decision of a mental health professional to disclose or not to disclose, when made reasonably and in good faith, shall not be the basis for any civil or criminal liability of such mental professional. Oh, so like if they do or they don't, they're not going to be held responsible? I don't know. I think that's what it's saying.